So, Michael, tell us, bring us back to the beginning of this case and what you remember, the details of representing Duane Owen and how you came into the fabric of this now 40-year-old case.
Sure. I can remember, I guess it must have been about, I want to say May of 1984. And I was a baby lawyer. I was in a firm where we all did criminal law. And it was a Friday night, I'll never forget this. And I got a phone call from now deceased Judge Richard Burke. And Judge Burke asked if I would be interested and would my firm be interested in representing Mr. Owen, on a court-appointed basis. Well, I knew that there were homicide cases. I knew that this was a death penalty case. I knew that this was a big deal. And of course, the first question you're going to ask as a lawyer, well, on a court-appointed case, how are we going to get compensated on a case of this nature? And I remember Judge Burke telling us, I know we can't respond now, but I remember Judge Burke telling us, don't worry, you'll get paid for all your time on this case. I would really like you to take this case. It would be, it would be a service to the bar. Well, I went back to the law firm, and since most of us did criminal law, we had a meeting about it, and we talked about it, and it was ultimately decided that one partner and I were going to take care of the Slattery case, and another partner and another lawyer in the case were going to take care of the Warden case. And we became his first attorneys. The case got an inordinate amount of attention. I do remember Mr. Slattery, when he was alive, was very, very vocal about this case. There had been a lot of homicide cases in Palm Beach County over the years, but this one got a lot of attention, and perhaps it was because of the manner of the accusation, the homicide and then the sexual assault, and the police had portrayed Mr. Owen, as being just the devil and evil and doing things. They did a lot of background stuff at the time, I think on young Karen Slattery, and I think they did some things on Miss Warden. I think Miss Warden was 38, Karen Slattery was 14. There was a lot of attention focused on that. And the atmosphere, and I guess from a law enforcement perspective, was, we're going to get this guy. This guy's going to get the death penalty. And, then the case began. And whenever we went to court, whatever we did, there was always something that created much more attention, because this was the Duane Owen case. It was assigned to a prosecutor who was an experienced prosecutor at the time and probably devoted most of her years when this case was on to just dealing with this and dealing with the Warden case. I have more memories of the Slattery case than anything else. One of the biggest memories I have is my partner and I did the motion to suppress in this case, and we thought we had a great argument because he was held there for hours and hours and hours. There was questions about whether he was being fed, whether he was going to the bathroom, whether he was properly taken care of. The officers in Delray were experienced, aggressive officers. They wanted a confession. They needed a confession. I think the confession was important. This was before we had a lot of DNA stuff. This kind of predated that as well. And they needed his confession. Well, at some point, Mr. Owen did confess. And I'll never forget, because this has not happened to me in any other homicide or any other case I've ever had. We do the motion to suppress, and Judge Burke asks a question. If I grant this motion, what happens to the case? And I remember the prosecutor distinctly standing in court with myself, with Barry Krischer, and basically having to tell Judge Burke that if she granted the motion to suppress, this case would go away, or the state would have to appeal it. And I just remember, within a couple of days, the motion to suppress was denied. I couldn't understand that. At trial, there was overwhelming evidence. There was the confession. There was physical evidence. We argued reasonable doubt and that the facts did not necessarily prove it. I think there was even an argument made that Miss Slattery was deceased. And as bizarre as it may have sounded to some, if she's deceased, then was Mr. Owen capable of sexual assault? Needless to say, that all fell on deaf ears. He received the death penalty. And then when an appeal was taken, we had a young lawyer who worked for us who went on to be a prosecutor and a judge, and he did the appeal, and he got a new trial for Mr. Owen on the Slattery case because the police totally did wrong. And you know, as we know, Mr. Owen was tried again, you know, in the late 90s by different counsel.
Well, who in your firm tried Georgiana Warden?
As I recall, it was an attorney by the name of Craig Boudreau, who was a former prosecutor and knew the criminal justice system very well. He was a very good trial lawyer. And I believe he tried it with Don Cole, who is now deceased. Don Cole was a former judge and tried the case with Don. And they handled Warden, we handled Slattery. It was, you know, like it was the Duane Owen law firm, you know, back then, because that's what we were doing. We had other criminal clients, but this case took a substantial amount of time, a substantial amount of work.
When the retrial happened, what do you remember about that investigation and the fact that how did you all look at the investigators and the police and the fact that he's now being retried because there might have been wrongdoing there? Is that
they were very aggressive. They stepped over the Constitution a little bit. I think that, if I remember, it was the totality of the circumstances. You know, when you take a statement from someone, there are certain rules the police have to follow. But you also have to be reasonable. You have to give somebody time to think. You have to give somebody time to use the restroom, to eat. And they were just pounding at Mr. Owen. And the Supreme Court didn't like that. And it was a big decision in an effort to go after that.
What do you remember of Duane Owen as you represented him, sort of the person and your interactions with him on a day-to-day basis as you defended him?
Everybody that I have read about has portrayed him as a monster. But when you are someone's lawyer and you get to know somebody and you treat them as if and you treat them like you would want to be treated, it's a different relationship. You know, as a defense lawyer, you don't look at what somebody has done in order to determine how you interact with them. You look at, do they talk to you? Do they talk at you? Are they listening to you? And in terms of him as a person, I found him easy to talk to. One of the things that I do remember about him is that he was very soft-spoken. He wasn't super aggressive. Now, if that's changed over the years since he's gotten older, you know, that could be the case. But he was very soft-spoken, almost mild-mannered, and it wasn't very difficult to relate to him, to talk to him. I know some people have made something about that smile that he has, that they've seen in court, and they've called it a sinister smile. It wasn't a sinister smile, it was a nervous smile. That's all it was. I mean, here this guy was subject to so much scrutiny and so much media attention, and the death penalty this, and confession that, and you did this. It was a nervous smile. But we never had any difficulty speaking with him. I never felt any fear of him, you know, when it was either one-on-one with him or with my partner with him. Never felt that. You know, he wasn't the way that he was portrayed. But of course, you're dealing with someone one-on-one and not as the media is depicting them. So it's totally different, you know.
When you kind of recall a lot of the events, I know as we were speaking, you know, you mentioned this, him being portrayed as one of the worst killers in Palm Beach County. And how do you kind of wrap yourself around of all the cases and people you've defended? Can you compare this one to others and in terms of the nature of the case and the graphic nature?
No, listen, I've been involved in a lot of homicide cases where there have been a lot of things that have been either done or allegedly done to people. And to each particular family, that homicide case is the worst homicide case. So when people call his case the worst case, or they refer to it as one of the worst cases, it really has to depend on your perspective. Look, 2 human beings died. That in and of itself is horrible. When you add on their allegations of sexual assault, when you add on their allegations of stabbing, it becomes a little brutal. But again, I don't look at it that way, because to every person who is involved as a victim in a homicide case, that's the worst case that they've ever seen. So I didn't look at it that way, because I think as a defense lawyer, if I got caught up in that, then I shouldn't be doing this kind of work. He was accused of a crime. The question was, could the state prove it? Were the elements there? Was there reasonable doubt? And did they have the right guy? And, you know, if they determine they have the right guy, then you got to determine if they can prove it. So I didn't look at it that way. But there are cases where the facts are worse than others. If it's a stabbing, if there's blood splatter, if there's, you know, somebody loses a body part. I mean, so every case is probably looked at and judged differently.
Well, when you look back now on this case, what are some of the things you remember most and will remember most as this case moves on and is studied? And
well, it's the first case in which I had a client in a case that I had tried that received the death penalty. I had done some death penalty appeals before Mr. Owen, but I didn't have a client who got the death penalty. So it's going to stand out there, notwithstanding the fact that he had a new trial. It's going to stand out that I don't think I've had a judge call me on a Friday night in the past 40 years, other than that one phone call I got from Judge Burke. And it's going to stand out that a judge asked a question in open court. What happens if I grant this motion? You know, Judge Burke was an excellent judge, a smart man, and any of us who knew him also knew that he was a character. And he didn't mince words. He came from a civil background. He practiced in Palm Beach. He got appointed to the bench, but he didn't mince words. And he cut right to the chase. What happens if I grant this? And I can still remember, it's now retired Judge Sandra McSorley, but it was Assistant State Attorney Sandy Kabush at that time. And I just remember she did not want to answer that question. And I can remember the look on her face when he asked that question. So those are the things that stand out.
As we look to the finality or potential finality of this case with Duane Owen and the execution that's been signed by the governor, the death warrant, what do you think, or what are your thoughts as this case sort of heads to, it's not final, no. Certainly for no one, but the next stage of this case, the next chapter will begin once he is to be executed, assuming that execution is still on? Well,
there's going to be all sorts of litigation between now and June 15th. I know that his lawyers are not going to give up, and just because the governor has terminated this warrant, that doesn't stop them. They can go to a higher appellate court, they can attempt to go to the U.S. Supreme Court. If in fact there's mental illness and Mr. Owen does not understand exactly what's going to happen, then it's very clear he should not be executed. And there are those that say after 40 years, you know, what are you going to execute him for? Let him spend the rest of his life in prison. Isn't that a far worse sentence? Well, you know, for those in the position of victims, they always want closure. You go from wanting revenge to wanting closure. Candidly, if the guy is not mentally right, they shouldn't kill him, and he should sit there. But that's going to be up to his lawyers, and whether or not there are doctors that can convince the particular appellate court that, you know, slow down here. You know, it's only been 40 years. What's another month? And, you know, what I don't want to see as the next 2 weeks begins, and we'll see it, is the same rush to execute him as there was in the beginning when this whole thing happened. Oh, it's time, it's time. You know, when I hear people say it's been all that time and all these appeals, it's now time to execute him, I don't necessarily agree with that. If he's ill, then we need to look at that. We shouldn't kill people who are ill, mentally ill.
Do you think he's ill? Do you think when you defended him that he was mentally ill?
There were some problems. Let me just put it that way, without getting into some things that I do recall that I probably shouldn't talk about. There were some issues there. There were some things that he didn't understand. There were those that said he was sharp as a tack. If you remember, you know, the Delray police said that he was taunting them versus them taunting him. But there were some things that were troubling. There were family things. There were issues there. And if, in fact, the current experts believe that that's true mental illness, then it would be horrible to take his life at this point.
When you think about this case and how it's going to be studied, what do you think people are going to look at down the line, and how are they going to look at this case in terms of it was extremely unique to the time, to the way things were handled, pre-DNA as you mentioned, and how the case was handled with a retrial and the way it evolved?
People are going to criticize this as, this is the typical death penalty case. Look at the appellate process. It happened 40 years ago. He went through all these different appeals. He had how many lawyers, how much money was spent, how much money was wasted. People are going to say that. And you're going to hear that in some law school class, you know, perhaps. But then you have to look the other side. You got a human being who's charged with the two most serious offenses that any human being can be charged with. They're going to take his life if he's found guilty and the punishment is executed. And you got to be sure. And I think the case will be studied both from a waste of time perspective. Why did we wait 40 years? Because that's the That's the criticism you usually hear. Oh, we'll get the death penalty now, but nothing's going to happen. But you also got to look at, there is an appellate process. There were police officers who at the time strong-armed them, were aggressive. I don't say they broke the law, but they did things that were not acceptable when you're taking a confession. There's been a wealth of case law in the past 40 years that has eroded, you know, what cops can and can't do. You know, it used to be if somebody just, you know, initiated the fact that they wanted a lawyer, but they didn't say the magic words, you could still go on and talk to somebody. Now, if somebody says they want a lawyer and the police don't clarify it, well, then there's a problem. Sometimes people can just reinitiate the conversations themselves, whether Miranda was read or not, and then the confessions are accepted. So the case law has changed. And it's going to be a case that is probably a very good case to study in law school or in a criminal procedure class. But I just hope it's not lost on the fact that if he is executed on the 15th of June, that it took too long and we wasted time and we wasted money. Because I don't think you ever do that on any human being. I think you really, even as the governor had said last week, and I think he made the comment that, you know, before you kill somebody, he said his words were to the effect of, you got to be sure. And that's a big deal.